He really is watching you. We've learned just how widespread the government's surveillance programs are, and they're doing it with the approval of a secret court.
That has privacy advocates outraged, and some are asking the Supreme Court to step in. Jennifer Wishon has the story from Washington.
The ways we can be tracked through technology advance constantly.
It's hard for you to know all the places where the information is being generated about you.
But privacy advocates say it shouldn't have taken an information leak for Americans to learn just how widespread government surveillance is and the legal justification it uses to carry out that surveillance, like when it asks major phone service providers like Verizon to turn over its clients' phone records, all in the name of national security.
They reveal who we talk to and when we talk to and who we talk to the most.
Giving Big Brother a legal peephole into your circle of contacts. The Electronic Privacy Information Center, or EPIC, this week filed an emergency petition with the Supreme Court. The group is asking justices to dissolve an order by the Foreign Intelligence Surveillance Court, which allows the NSA to collect the records of millions of phone calls made every day by Americans right here in the U.S.
And they're collecting this information, as you said, about people who, may have done nothing wrong or not be implicated in a national security investigation at all.
Here's the issue. The Foreign Intelligence Surveillance Act, known as FISA, includes language that allows the government to collect business records, in this case, Verizon's. But the law says the records must be relevant to a national security investigation. The problem is in interpreting that law. A secret FISA court is in charge of approving what records the government can collect. And that court is reportedly defining the word relevant very broadly in terrorism cases. So much so that experts say the government can gain access to virtually any electronic information.
The specific files requested have to be relevant to a specific investigation. Whereas what's happening right now is bulk collection of all call detail records of Americans under the theory that at some point in the future they may become relevant to some investigation.
The sheer overcollection of information on Americans right there is troubling because it's hard to see how that complies with existing law and constitutional restrictions. And then once the government has that information in its databases, there are very few limits, not enough limits, on how the government can use that information for subsequent purposes. So that raises a whole lot of potential for abuse.
Potential abuse that some fear will eventually lead to a state of constant surveillance.
It's a critical question of scope, because if the interpretation of relevance under this law is going to be some interpretation that we've never seen before in a criminal court or civil court, then the public has a right to know.
The NSA collects information in the name of national security, but Franklin says security and privacy don't have to be in conflict.
In fact, if we make sure to have appropriate standards and require the government to establish an appropriate predicate, a connection to terrorism when they're collecting information, that is actually going to make their programs more efficient. They're going to be going after the real bad guys, and it's also going to protect privacy by limiting the intrusion on the rights of innocent Americans.
For now, the government, the courts, and Americans have to figure out how much surveillance is acceptable and necessary in the name of security. Jennifer Wishon, CBN News, Washington.